So as some of you know, I've been on the board of trustees for the Inner City Law Center for many, many, many years. And as part of that, the Inner City Law Center is one of the largest, if not the largest, homeless slumlord advocacy groups, not only in LA, but in the country. And they advocate for low-income housing and to prevent and sue slumlords for bad behavior. And I tried a case a couple of years ago for them where we got a 7-figure verdict plus punitives. And then we donate all of the fees back to the center. And it's very gratifying. It's very effective work. And they need trial lawyers so that when they negotiate with landlords, they know that if it doesn't settle, that they've got somebody like me or others that come in and try the case. So I've got another one with 60 plaintiffs in a downtown housing project with slumlords that are changing their names to try to avoid responsibility. You got leaks and roaches and mold and bed bugs and all of the stuff that really is horrible. And I say all that because I want to talk about the questions that they had about what are we going to do from now on with discovery. And I said, how many persons most knowledgeable depots have we taken yet? We haven't done any yet. And I said, well, that is where we start. And I want to talk about the PMK depot, person most knowledgeable, sometimes called a PMQ, person most qualified, same thing, right? In federal court, they call these 30B6 witnesses. But what it is when you have a defendant that is not an individual, if they're a corporation, an LLC or whatever, then you can require that defendant to designate a person to speak on their behalf who is most qualified in whatever topic you want. So for example, we're going to notice the person most qualified, most knowledgeable at the slumlord property management company on the issue of repairs done to the property from year to year, the communications with tenants from year to year, documentation for year to year, complaints from the city year to year. Let me tell you why it's so important. Because they're required to put forth someone who will testify under oath that binds the company. And many times when you have unscrupulous corporations and you say, I need the person most knowledgeable for communications with the tenants about repairs. If they say, well, we don't have one. Now, what I've effectively done is I've shut them down from putting on any evidence at trial that they communicated with the tenants about repairs because they don't have someone who would be the most knowledgeable to even mention or talk about it. And so you effectively cut off that testimony. You take a PMK depot and you ask them about whatever it is, what documents exist, etc. Remember, this is the person who knows more than anyone else. If they don't say that they know this at the deposition, at trial, if the defendant tries to put on other evidence, I'm like, no. I talked to the person who supposedly knows the most, and they don't know. You're sandbagging me, and it's a very effective way of culling down what is at issue. And I say that because a lot of people use special interrogatories, contention interrogatories, to try to limit or, nail down certain issues. And it's a complete, in my opinion, waste of time, waste of effort. One, because any of your contention questions go through the lawyers that then file 5 pages of objections. They don't answer the question. It's watered down. It's not on video. You go back and forth. You meet and confer. You file motions. And at the end of the day, all you have is an answer that still has a million objections. And if you try to read it at the trial, the jury doesn't understand this is burdensome. Oh, and notwithstanding those objections and heretofore with reserving our rights, we say X. Instead, you have a person most knowledgeable depo on video, and I'm saying, did you communicate with any of the tenants about repairs? I don't know if we did or not. I've just now excluded them from putting on any evidence that they did. And that depo can happen in 20 days. And we're done. And now I don't have to do anything more on that issue. Or if they do tell me, now I know where to go and look. And so I always tell people, look, deposition and taking deposition skills is way more important than being able to do a closing argument, an opening statement, whatever, because in every case you're taking depos. In 1%, you're trying a case. So people are saying, Mike, tell me when you do closing down in San Diego? I'm like, great, I love it, but you should probably come to my depos, right? Because you being able to do that is going to affect every one of your cases, not just the 1% that you try, right? So I think it's very effective because you can do a PMK or a regular depo within 20 days after serving a defendant. You can notice their depo to happen, depending on how you serve it, 15 to 20 to 30 days later. And now you have all of the parameters within a month and a half of filing your complaint, when maybe another lawyer is like, well, I sent 500 special interrogatories. I'm like, well, in 2 years, you may get some watered down crap, but I'm going to know in 30 days. And as I always say, leopards don't change their spots. Lawyers that know about PMKs, that put people on the spot, that ask a PMK, and the PMK is trying to be slick and like, well, not to my knowledge. And I'm like, okay. And then people are like, Mike, why didn't you follow up? I'm like, because I just excluded them from talking about it in the future, right? Why do I want to browbeat him into telling me an answer when he says I don't know and I can exclude it, right? But having that knowledge, knowing how to do it and doing it means everything to the insurance company, to the defense lawyer, when they realize that lawyers that know how to do that know how to try cases. Lawyers that know how to do that have resources that they're not going to be afraid of spending at trial. Lawyers that do that walk away from bullshit offers, don't agree to mediation without certain parameters. Send 998s, and when those 998s run, we go way above the 998. Don't agree to trial continuances. And what does all of that mean? Is those leopards get the big settlements that you see all over the place. Right? It is the other leopards that don't do that stuff that complain about, why are we getting drugged out? We get these lowball offers. Man, nobody wants to do anything, etc. It is because they figured out what kind of leopard you are. And depositions are the single most important way to show what kind of lawyer, what kind of leopard you are.